My name is Michael Cohen. I'm an attorney for the state now in California. I was an attorney for cities and counties across the state. Obviously, goes without saying, but I'll say it anyway. I'm here in my personal capacity, but I've sort of been able to see the contracts and compliance sort of process from a lot of different angles. And so I'm excited to try and present this in a way that is comprehensible and easy to wrap our arms around, and hopefully isn't too technical and dry. So the law is a big technical concept here. And like I said at the outset, I don't want to try and, make lawyers out of everyone in 30 minutes, but I do want to help you sort of hone intuition that will at least trigger alarm bells when a legal problem might be coming down the pike. Yeah, and I also just sort of want to help us get a flavor for all the different types of laws that apply in this context. So there's a logic to everything, and I sort of hope this presentation helps reveal that logic to you. And then finally, this third learning goal, I wanted to make the point that using attorneys well leads to better outcomes for you and lower bills. So I sort of hope I can help you understand how attorneys slot into this process so you can use them efficiently and to the greatest effect. With that said, I want to quickly jump in to some Civics 101. In the US, legal authority, and by extension, the rules that apply to all of us and everything that we do, flows from the top down in a system called federalism. And one way of envisioning this is as a layer cake. So each layer sort of covers the layers beneath it. And as you move down, things get more particular as to a jurisdiction. Notice I didn't say specific, because many federal and state laws are very, very specific. But as we move down the layer cake to the local level, the rules sort of get more idiosyncratic. They get more particularized. So there are a few legal concepts worth knowing just to sort of set the stage for how this legal authority flows. But the one I just wanted to highlight today relates to how laws from higher levels of government interact with those from lower levels. So in a nutshell, federal laws is supreme. That's the head honcho, thanks to the Constitution Supremacy Clause. And that overrides, or in legal jargon, preempts state and local laws. But things get a little bit more complicated lower down, which we'll talk about a little more later. Generally, state law is supreme over local laws, but some states grant cities special powers to legislate above and beyond, and even conflict with state law. Those are called home rule states. There are a ton of those, including California. And like I said, I'll mention it briefly down the road because it does come up. But the important thing to know here is just that the laws that guide public procurement come from every layer of the layer cake, with the higher level laws sometimes, but not always, dictating what the lower level laws can do. And that's basically how the system of regulations works in this space. So what's with all these rules? We'll get back to something a little less technical here. A lot of the laws that govern public procurement derive from the same set of public policy goals. So if you just understand the reasons for rules applicable to government procurement, that can help you understand the scope of the rules that exist, as well as the sort of details of their design. So I think if you keep these public policy goals in mind, it should help you spot potential issues in the procurement process that might be best brought to an attorney, or at least given some sort of extra thought and care. And I want to emphasize that oftentimes multiple layers of the layer cake want to legislate in these areas. So bear that in mind when thinking about the regulatory infrastructure in play here. So, you might have state law relating to where public money can go, but then you also have local law relating to where public money can go. So the four, I think, key public policy goals that underlie the laws that regulate public procurement relate to creating a fair, open, and competitive process. So this sort of relates to, getting the most bang for your buck in the public procurement process, and also making sure that no one's being unfairly disadvantaged, and also that the public can sort of see what's going on. Second, you want to really ensure that public money is used for the public good. So there are legal limitations here that we'll talk about. Public money can only be used for certain purposes. Third is protecting both the public agency and the offerer. So there are protections in place to make sure that everyone gets a sort of fair shake. And then finally, there are these ethical concerns relating to largely conflicts of interest, but conflicts of interest here sort of encompasses issues like favoritism, connections, nepotism, all these things that sort of relate to this first public policy goal of making sure this process is really fair. So this can sort of seem like a lot to put on the public procurement process. I mean, these are big goals. But it's necessary because the process is, first of all, really important. And second of all, presents some really significant legal and ethical hazards. I think some people have seen examples where this missteps can really undermine the public's overall confidence in the agency's financial practices, but also just undermine confidence in government more broadly. And one reason I wanted to highlight these at the outset is that, it's important to know that laws that have fallen into these general buckets are out there. And I'll illustrate why. One time I was working for a company that bid on a contract for services in a special district down in Southern California. And unbeknownst to me, another person at the company had a longstanding relationship with one of the board members of the district. And that board member had texted my colleague before the presentation to say, hey, are these guys legit? What should we think of them? We eventually won the contract and had reason to rejoice. But then once the contact between the parties came to light, the agency got squirrely and they actually canceled it. So if my colleague had thought about the broader principles relating to avoiding conflicts of interest and, by extension, avoiding favoritism, that might not have happened. So it pays to know this stuff is my point. So where do the rules come from? This is basically each layer of the layer cake. Not exactly in the order that it is in the layer cake itself, because you'll see I put federal law and grant restrictions on the bottom, and I'll talk about why. But the sources of applicable legal authority for public procurement, they come from state law. They come from municipal enabling legislation. We're going to talk about that. It comes from board and council policy decisions. We'll talk about that as well. And then finally, these federal law and grant restrictions. I put it at the bottom here because oftentimes these are not going to be the sorts of things that are going to sort of win the day in terms of what obligations and compliance actually looks like at the ground level. But that can change depending on what sort of grants you get and from what agency. But I think, when you're thinking about public procurement in the local government sector, really state law, the first three are going to be the ones that are going to be driving most of the particularities of the process. So I'm going to go through each of these four different sort of sources of legal authority and just talk a little bit about what each sort of looks like. In state law, obviously every state is different, but you're often going to see laws that relate to these sorts of things. So public transparency, like we talked about, a key goal in regulating the public procurement process. In California, we have the Public Records Act, which allows members of the public to request documents from public agencies. We also have the Brown Act, which makes meetings of legislative bodies public, so you can watch meetings of a town council or something and get their agenda materials. Many states, if not all states, have very similar regulations related to public transparency. There's some regulation of bidding procedures. So, for example, in California, we have the Uniform Public Contracting Cost Accounting Act, kind of a mouthful. This just allows for sort of uniform public procurement processes. It sets out requirements for when you have to use certain types of mechanisms and just make sure that there's going to be some uniformity across the state. It might cover things like what sort of, bid protests you can make and so on. We'll talk a little bit about that. And there's vendor qualifications. Oftentimes in state law, this will look like making sure that competence or qualifications take precedence over value. In California, we have the Mini Brooks Act. A lot of states have something similar. It just makes sure that, a public agency is not always just going to award a contract to someone who's cheapest, which I think to all of us makes a lot of sense intuitively. We want to feel like our government money is being well spent and going toward not just who's cheapest, but the vendor who's going to give us the best quality of services. There's always conditions on public work. Some of that comes from federal law, but state law as well. Parts of the labor code in California are on point here. Every state has some regulation of the types of the conditions that might apply to work that takes place on public projects. There's conflicts of interest provisions. Again, every state has something to this effect. In California, we have the Political Reform Act and Government Code Section 1090. These just say things like a public agency can't enter a contract, or a member of a public agency, say a legislative body, can't enter a contract in which they have a personal interest. So, a family member is going to benefit or something. And these are just laws that regulate the ethics of the public procurement process and make sure there isn't any undue favoritism or nepotism, making sure that everything is given a fair shake. And finally, there's restrictions on public funds. So like I said, public money cannot be used for any purpose. In California, there's a constitutional provision on point, Article 11, Section 16. You can't effectively give what's called a gift of public funds. So, money has to be spent for a public purpose. And in public procurement, that's just fine. A city or town is entitled, or county is entitled to use public funds to procure services for its residents. But something that is totally way out of whack, like paying millions of dollars for something small, maybe they're susceptible to a challenge on the basis that this is a gift of public funds. So I just wanted to flag those types of restrictions. All these are generally creatures of state law, but like I said, sometimes you'll find restrictions like these in other laws as well, be it federal or local. So municipal enabling legislation, this is a little more interesting in some respects. Local law is going to set the parameters by which procurement is undertaken in that jurisdiction, obviously subject to state and federal law. There are two potential sources of authority here that you can look at. You'll recall that some states, I called them home rule states, give certain local governments extra authority to make their own rules. The mechanism by which a political subdivision or a municipality claims that authority is through what's called a charter. Charters are like the constitution of a city or county. So there are charter counties and charter cities, and those have different scopes of special authority under a state constitution. And then on the flip side, we have what are usually called general law cities or counties. Those are just agencies that default to the general law or the laws that state law applies and dictates the outer limit of local authority. So those are the two sort of main areas where municipal law is going to come down. So in a general law city, the main source of local legal authority is just going to be a municipal code. And in a charter city, you'll get two sources. You'll have a municipal code, and then you also have the city or town charter, which, like I said, is sort of the constitution. So it's just important to know that these sources of legal authority are different. You may have to look in different places to get a sense of the applicable rules of the road, depending on what sort of local public agency you're actually working with. And then to go down and layer cake even further, you have board and council policy decision. This is where the stuff really comes to a head. Purchasing or procurement policies are sometimes called, are things that are adopted by local government bodies. They may be developed by staff, by a procurement division, but usually adopted by a local government body, like a town council or a city council. And they give you a broad overview of the standards and guidelines for purchasing goods, contracting services, constructing public projects, and they can include all sorts of things. I've listed some here, but they can also include, mechanisms to protest contract awards, mechanisms to promote giving contracts to certain protected classes or local businesses, mechanisms to favor even certain types of production. So as long as it doesn't violate some other law, these policies can be really creative. And, because they're governed by state law and federal law, they're not going to change dramatically. But there's going to be some serious sort of window dressing changes from agency to agency. And this is where often, it's a very useful place for folks who are looking to be a vendor in a local jurisdiction to look, because it's going to give you the most sort of rubber hits the road guidance on what compliance actually looks like when selling or bidding on a particular contract for a particular public agency. So finally, there's federal law and grant restrictions. You might think that all of federal law applies to all of us. That's not an unreasonable assumption. That's actually not quite true. Some laws need a mechanism to become applicable to private parties like you guys who are, looking to sell into public agencies. Federal funding is one of those mechanisms. So when you accept federal funds, you're also accepting a slate of terms and conditions. I thought one sort of cute way of thinking about this is the 4 W's: who, what, when, where, who the terms apply to, what those terms are, when the terms apply, so duration or term, and where the terms actually come from. So when you're accepting public funds from the federal government, again, it might be that you're ceding or accepting these sorts of terms and conditions on that money. And that final W dovetails into the second point I want to make. There are terms on federal funding that apply nearly universally, and there are others that are particular to a certain agency or department. So the terms that apply can vary widely. And it's just important to know that when you're getting a federal grant, it can be quite a lift to make sure that you're complying with these terms and conditions. It's not uncommon for small startups, for instance, when they get a large federal grant, to hire folks specifically to do grant management because there's a lot of reporting requirements, there's a lot of other compliance measures, and you need to make sure that you're complying with those, lest you have to give the money back or face some other type of penalty. So there's a little bonus here that I wanted to add. This isn't formally the sort of thing that is thought of in the sort of federalism layer cake we talked about, but day-to-day management decisions are really important. Yes, they're informal, but they're no less important than the formal laws that apply to all of us, and especially public agencies. I don't have to tell you that governments are nothing but just a group of people on the ground making day-to-day decisions, and the procurement process might task those people with making discretionary decisions. So maybe it tasks them with figuring out whether a certain type of bidding procedure should apply in a particular instance. And the decisions that are made on the ground there are just as important as anything that's written in stone. And so it's valuable to know, that sometimes developing personal relationships with officials who are going to be helping guide this process can be important, so you know what sort of discretion actually lies and whether or not, it's likely that the discretion is going to be exercised in a way that is in your favor or not. So I wanted to offer 5 questions that might help you home in on what rules apply to a particular procurement process. There are a lot of different ways to organize this. I have no pride of authorship here. This is definitely imperfect. This is just one way of organizing this sort of set of questions, but I hope it's at least a little useful. I think the first question when you're thinking about what rules are going to apply to me as I'm looking to enter the public procurement process with a particular local agency is what type of public entity are we talking about? Another way of putting that is just, what layer of the layer cake are we in? Is there a municipal charter that supersedes the public contract code on specific issues? Is the specific entity required to competitively bid its contracts, or is there something else going on? The second is, what type of procurement are we talking about? So most vendors are only dealing with one sort of type of procurement. That's not true for large companies that might be selling different types of goods and services, but you might be selling professional services. You might be selling construction or procurement of materials and supplies. Each have their own requirements, and so it's important to know what type of procurement you're in, so you know sort of what universe of compliance you're in. And then finally is what type of project. So some projects may require environmental review or certain permits. Others could come under the jurisdiction of a particular government agency. So again, it's just important that you know your industry, what sort of projects you're offering, and what sort of regulations are going to apply to that type of project. Fourth is what is the context of the procurement and the parties involved. This is sort of a clunky way of getting at this idea that there can be issues that arise related to conflicts of interest, issues of delegated authority or agency, who has the authority to do what things, and those all have very serious implications. So by context, I mean really what's the relationship of the parties in the procurement process. And then finally, what funding sources provide requirements, or maybe another way of putting that is just what regulatory agencies have jurisdiction over the work. So are there federal funds involved? Is construction regulated by the state? For example, you're building a hospital. Does the work fall under a particular regulatory regimen? Like, for example, the construction of jails. So these 5 questions, again, they're imperfect, but I think it'll sort of start to get you in the ballpark of what sort of regulatory infrastructure you're looking at. Okay, so where do attorneys actually fit in? I think perhaps, I'm not sure if everyone on this call has in-house counsel or counsel they regularly refer to, but either way, attorneys, if they are involved in the public procurement process, these are sort of the things they can offer for a private company who's looking to enter this world. So they can review the solicitation and identify the solicitation being, the call for bids or offers, and identify certain eligibility or conditions, help you figure out if you're actually eligible to bid on a certain type of project. They can identify grounds for actually protesting the solicitation itself. Maybe you think the solicitation is just unfair or something isn't right. They can help you figure out what to do in response to that. Then they can help you with those protests if you end up moving forward, or any negotiations. Let's say it's a competitive negotiation. They can negotiate on your behalf or advise in the negotiation process. They can review your own proposals for both responsiveness to the solicitation and just sort of overall completeness as a package to make sure no issues are going to arise. And they can also advise on the developing a process internally for meeting the conditions of solicitation such that your proposals are going to be sort of on point and right the first time around. Obviously, they can do very normal attorney things like reviewing contracts and amendments and change orders, those sorts of things. Advise on permitting or review processes that might apply depending on what sort of project is in play, and then advise throughout the life of a contract. Those are the sort of things that an attorney might do. You may not need to lean on an attorney for all of these things, but those are the sorts of services that are typically available. And on the flip side, just to give you some perspective, and this is a world I'm slightly more familiar with, is just what are public agency attorneys actually doing on their sides? What's the city attorney's office or the town attorney's office or outside counsel actually doing? It looks really similar, but they're going to be doing be a little bit more proactive because they're the ones who are actually going to have to, the public agency is the one who's going to have to decide on the procurement method and actually, compose the solicitation before it goes out. And the attorney is going to be involved in a lot of different steps in that process, confirming which procurement method applies, whether the solicitation meets all legal requirements, whether it's fair to everyone. And then, much as like an attorney for a private company or vendor, it's going to assist, an attorney can assist in sort of every feature of the procurement process moving forward. So making sure proposals are complete, making sure protests are responded to appropriately, assisting with negotiation, reviewing contracts, etc. And then finally, there's public agency staff. So these are the people who are really doing the heavy lifting, in my view, on the public agency side. These are the folks who are really trying to understand the needs of the agency. They're the ones who are putting together the solicitation for attorney review, if it's appropriate. They'll be developing the cost estimates and the scope of services, and then actually administering the procurement process, publishing the relevant documents, receiving the bids, opening the bids, preparing contracts, those sorts of things. Thinking proactively even about, replacement services or what happens after a contract ends. So that's what staff are doing on their end. So I hope that helps sort of give a glimpse of what's actually going on inside local government when this public procurement process is initiated. So I want to conclude with just some sort of this final thought, which is that in the public procurement process, especially in the local government world, it's really about the small things. The law, as we've sort of briefly, superficially covered, is huge. There's federal law and state law and local law and sort of hyper-local law that applies to this process. But the process that you need to follow is really small and narrow. It's going to be spelled out for you to some extent. Obviously, there are plenty of hazards that you need to be aware of. But just because there's all this law that applies, it doesn't mean you have to know all of it. It just means that you need to know where to look to comply. Know that there's this universe out there of law that's bearing down on you and that's helping shape the regulatory infrastructure with which you need to comply and make sure your processes are sort of shaped too. So I've indicated here that there are like a couple different tips that might actually help when you're thinking about how to track down the small process that you need to follow. I think that checking the web public agency website is at the forefront, an incredibly useful measure. There may be a department or a division within a public agency that is going to publish the relevant documents. So at the state, there's the Department of California, there's the Department of General Services, Procurement Division. Lots of local governments have their own procurement division. Maybe it's within the Department of Public Works or the city manager's office. Maybe you're going to be dealing with a particular department who's going to be publishing their own documents, or maybe you're going to be dealing with sort of a town or city-wide department or division. But check the website. Most of the information you need is just going to be on there. And to the extent that it's not, you can contact that relevant department or division or official. Maybe it's some sort of procurement official to make sure that you have all of the information that you need. And then finally, I'm just going to suggest that it's very useful to read the fine print. I know that's very lawyerly, but oftentimes when a public agency publishes documents here, they're going to be fairly comprehensive, and it can really pay to just take a minute, sit down with the purchasing policy, and just make sure that you understand everything that's going on there. And oftentimes, materials that are available on the website are going to answer all of your questions. So that is sort of my brief and speedy run through of what compliance actually looks like in the public procurement process.